Tanzania, elsewhere, and particularly in reference to Barrick Gold Mining, a company we all know well, living in Vancouver. So just very pleased to have you here and to hear this talk. Welcome. I'd also, sorry. And please, just want to remind everybody that we are guests on Musqueam land here on UBC. Thank you.
Okay. Bear with me while I click it. All right. Good afternoon, everyone. I hope those on Zoom can hear me clearly. I first want to just say thank you so much for this invitation to join the IRES speaker series. It truly is an honor to be invited by colleagues from outside the law school to speak about my work. I do find that you get into a bit of a silo in our different departments here at UBC, so it's great that those in IRES saw my work and thought it would be worthy of sharing with you in the speaker series. So this presentation is based on some preliminary research that I've undertaken as part of a SSHRC Insight Development Grant that I was awarded in 2021. A lot of the proposed field work for that project has been postponed due to the pandemic. So a lot of the empirical research and data that I'm relying on for my presentation is from two NGOs that have done really incredible work on the ground in Tanzania at the North Mara mine. So Mining Watch Canada and Rights and Accountability in Development, or RAID, which is a UK NGO, have been reporting on the violence, harassment, and other human rights violations that have been committed at the North Mara mine. So in this early stage of my research project and sort of been thinking about and sort of conceptualizing some of the ideas at this stage in the project, I've really relied on a lot of the reports that they've done over the last decade, really. And I'm really truly grateful for the work that these two NGOs have done to shed light on the horrific mining conflict involving Barrick Gold in North Mara, Tanzania. So my presentation is sort of divided into four parts. The first is I want to provide you with sufficient background and history to the conflict at the North Mara mine in Tanzania, which is located here on the map. The mine is in the Tarim district of the Mara region of Northwest Tanzania and is situated on the land of the Kuria indigenous peoples. I'll then discuss some of the rationale for operational level grievance mechanisms as articulated in the United Nations guiding principles on business and human rights. And then I'll share some information about the grievance mechanism at the mine, as well as some concerns that Mining Watch and RAID have reported in their over 10 years of actually reporting on the conflict. And then I'll examine what is essentially the crux of my SSHRC project, which is my contention that this grievance mechanism and sort of parts of the conflict more generally have contributed to what I call state transformation in Tanzania. And then for my conception of state transformation, I rely partly on work done by Dr. Jennifer Ladner at De Montfort University in the UK, who's done work around how transnational law, especially transnational investment law, has really affected constitutional developments in Mongolia. So I've taken her framework and sort of adopted it to look at the role that Canadian mining companies have played in two mining conflicts in Southern Africa. And so the framework that I sort of proposed in my SSHRC grant is one that I want to share with you to help situate this presentation and sort of the project that I'm undertaking more generally. So it's well known that the overseas operations of several Canadian mining companies have been marred by conflict. And the ways in which Canadian mining companies often exploit vulnerable populations in a weak governance environment to exert considerable influence over various domestic affairs related to their overseas operations in other countries has already been fairly well documented. And these exploits have often contributed to disputes with local communities and the governments in the countries in which they operate. And so my reading of some of these conflicts as I was thinking about this project I came to understand that the possible sources of the conflicts, like what actually contributes and leads to the conflicts, as well as proposed remedies and regulatory reforms that could potentially mitigate these conflicts from happening again, were already being extensively studied. But what hadn't been fully examined just yet, especially in the African context, was the extent to which such conflicts have transformed mining governance and regulation and altered state practice in these areas. And that's sort of, again, how I've conceptualized state transformation as it relates to two mining conflicts that I chose to examine in this project. One of which is Barrick Gold's in North Mara, Tanzania, part of which I'll speak to today. And the other is related to a Canadian company called First Quantum Minerals and the conflict that sort of embroiled their operations in Zambia. And so the deeper dive that I want to do into these two conflicts is to, use them as a way to reveal the extent to which Canadian mining companies are contributing to state transformation in Africa, because it is an under-researched field. And Canadian mining investment in Africa is significant. And so it's part of why I want to get a fuller understanding of what Canadian mining companies are doing in the continent and how conflicts that arise from their operations are really contributing to institutional change and reform. Yeah, so a lot of the Canadian mining investment in Africa is quite significant. And most recent figures from Natural Resources Canada indicates that Canadian mining companies have about $37 billion worth of assets in African mining projects. So it became clear in the early stages of really sort of conceptualizing this project that this investment, especially when it's accompanied by conflict, has a significant impact on mining governance and the regulatory framework in affected countries. So thus far in the project, I've decided to try to narrow my analysis to 4 specific areas in which we see these conflicts really have an effect on institutions in affected countries. And the first is in the area of operational level grievance mechanisms and the focus or the impact that these have on access to justice and remedy for victims of abuse at Canadian-owned mines. And I'll share more about operational level grievance mechanisms when we look at the North Mara mechanism. The second one is mine security and the use of private security firms or police forces to guard the mines, which is actually a pretty common practice at a lot of Canadian-owned mines across the continent. And the special arrangements that are in place at a lot of these mines, and my research is revealing, really tries to kind of subverts the rule of law and the way in which governments can actually protect and enforce sort of laws and the private property protections at the mine with respect to the local community. The third is through forced displacement or evictions of local communities from the mine site, often without fair compensation. And sort of linked to that issue of forced evictions and displacement is the extinguishment of customary land tenure and ownership. And that has been done in an effort to recognize, or to not recognize, any claims by community members to the land and the rights that would accompany any such claim, thus giving the government in question the opportunity to actually advance the interests of the mine over that of the local community. So let's turn our attention now to the North Mara mine. And I want to briefly give you a timeline of the mine, just so you can understand, again, the extent or the breadth of which this mine has been in operation and the toll that the mine has really taken on the local community and the interventions that the government of Tanzania has attempted or not attempted in order to alleviate the situation at the mine. So commercial operations at North Mara began in 2002. And in 1999, the Tanzanian government had signed a mineral development agreement with East Africa Gold Mine. This company subsequently became a Canadian company called Placer Dome, which acquired it and named it their subsidiary in Tanzania, Placer Dome, Tanzania. In 2006, Barrick Gold acquired all of Placer Dome's assets, and as such, directly or indirectly owned all or majority interest in the North Mara mine through various subsidiaries since its 2006 takeover. In 2010, Barrick incorporated Africa Gold, a wholly owned subsidiary based in the United Kingdom, to control its Tanzanian operations. And this was after reports of human rights abuses began at the mine in 2008. In 2014, Africa Barrick Gold changed its name to Acacia Mining in an attempt to distance itself a little from Barrick. I'm sure that was a little bit Barrick's doing as well, to sort of distance itself from the allegations of abuse that were arising at the mine. Barrick retained 64% interest in Acacia Mining. And then during this period, ongoing reports of violence against members of the local community continued, including reports of at least 22 killings and 69 seriously injured as a result of what was called trespassing onto the mine site. In 2014, the first North Mara grievance mechanism was established by Acacia Mining. The grievance mechanism was reformed in 2017 in response to some concerns. And in 2019, Barrick purchased all of the outstanding shares in Acacia, and thereby acquired 100% ownership and control of the North Mara mine. In 2019, in an effort to sort of respond to some of the concerns at the mine, as well as an ongoing tax dispute that Barrick had with the government of Tanzania, Barrick entered into a joint venture agreement with the government of Tanzania called Twiga Minerals Joint Venture. And as a result of that joint venture, the government of Tanzania now owns a 16% stake in the North Mara mine. Since the Barrick takeover of Acacia and the creation of the joint venture, violence has nonetheless still continued at the mine. And recent reports just from this past March and October by RAID and Mining Watch Canada have pointed to ongoing reports of police violence and killings against local community members. And as I said, a lot of the killings and the harassment that's taking place at the mine is associated with individuals that the mine has called trespassers. And these are members of the local community whose livelihoods were really destroyed by the mine. And in an effort to actually seek additional income, ways to support their families, some members of the community do enter the mine site and do try to scavenge for gold, not by accessing the actual focal point of the mine, but through sort of the mine waste and other sort of areas of the mine in which they could try to scavenge for gold. And because of that, and in efforts to prevent that from happening, police have used violent mechanisms and use of force to actually prevent individuals from accessing the mine. And so in total, Mining Watch Canada and RAID have reported at least 50 deaths on or around the mine site between 2008 and 2017, when the grievance mechanism was reformed in 2017. And the violence was so severe at the mine that a lawsuit was actually filed against Acacia in the UK in 2013. And this quote from RAID's, a report by RAID in 2019, essentially captures the essence of much of this abuse. And I won't go into it in too much detail, nor the lawsuit, but just to say that it's a pretty egregious accusations that have been leveled against Barrick and its subsidiaries at the North Mara mine. So in response to the tensions and the conflicts that could arise with respect to extractive projects like mining and other corporate activities, the international response has been to try to temper corporate misconduct and ensure corporations have mechanisms in place so that victims of any human rights violations or environmental violations committed by the corporation could receive some type of redress and remedy. And the United Nations Guiding Principles is really has become that standard bearer in international business and human rights to implement and to assert sort of the ways in which states and corporations can govern the field of business and human rights to ensure that victims of corporate misconduct do receive some type of redress. And for those who are unfamiliar, the guiding principles were adopted in 2011 by the United Nations Human Rights Council. And they're comprised of 3 pillars, which I pictured for you here today. The first of which is the state duty to protect against human rights abuses by third parties, including corporations. Corporations have the responsibility to respect human rights. And the third pillar is greater access to remedy for victims through effective judicial and non-judicial grievance mechanisms. And access to remedy is an important right that is intrinsically tied to the foundational legal principle that where there is a right, there must be a remedy for its violation. And so access to remedy and availability of an effective grievance mechanism to redress any concerns or complaints that victims of these human rights abuses may have has become a really critical component of the business and human rights agenda, and is considered a really important element of a company's human rights portfolio. So operational level grievance mechanisms in the UNGPs are meant to be sort of project level grievance mechanisms that are facilitated by the company or any external parties that are contracted by the company. So these mechanisms are meant to offer affected communities a chance to bring grievances directly to the company and receive compensation as a remedy in most instances. So Principle 29 of the UNGP sort of captures what the business and human rights movement really thinks is the purpose and the essence of these grievance mechanisms. And in the UNGPs themselves, the commentary to Principle 29 outlines that they're meant to perform 2 key functions. The first is to identify adverse human rights impacts by providing a channel for those directly impacted by the company's operations to raise concerns. And the second is to enable early remediation, so thereby preventing future harms from compounding and any grievances from escalating. In addition to identifying what the 2 functions of a grievance mechanism entail, Principle 31 of the UNGPs captures certain effectiveness criteria. And I won't discuss these in detail in the interest of time, but I will say in some that the criteria are framed to ensure that the grievance mechanism is legitimate, so there's buy-in from the community, that it's accessible, so that members of the community don't face any obstacles to actually actually using the mechanism, that there is some sort of equity between the complainants and the company, so ensuring that the company in no way sort of hinders the process, the grievance process for the complainants by withholding evidence or obstructing the process in any way. And as well as that there be transparency in the process so that complainants understand what the grievance mechanism actually involves and that they could pursue it without any, as I said, any sort of obstacles. Now, despite the potential convenience and efficiency of operational level grievance mechanisms, as you can imagine, there have been concerns about this practice. And here I really turn to the work of Dr. David Zablowski at York University, who has argued that operational level grievance mechanisms are part of what he theorized as a legal enclosure due to the territories of extraction that are created by the state and the mining company. And this is essentially to say that through mine sites and a grievance mechanism that is operated by the mining company at that mine site, is that it's creating an enclosure around the ability of complainants to fully access justice, because they are forced to actually turn to the grievance mechanism that that company has created, and oftentimes are prohibited from pursuing justice outside of that mechanism. And some of the concerns that have been raised by civil society with respect to grievance mechanisms at the company level are questions around barriers to access, that they don't actually offer anonymity and prevent reprisals against complainants. They actually may prohibit in a number of instances complainants from seeking judicial remedy, whether it's within the host state, like Tanzania, for example, or in another jurisdiction. They may not actually be developed in consultation with the community to eliminate or reduce barriers to access. And they actually, in a number of instances, don't adequately address complainants' grievances. And so in this 2019 report, RAID sort of summarized the grievance mechanism at North Mara as follows. It's comprised of 2 steps, so it's a really simple and straightforward grievance mechanism. And the first is just to identify if there's an adverse impact involving the mine or a third party that is linked to the mine. And if such an impact is confirmed, the second step is to simply identify a remedy. And oftentimes the remedy that is offered and the remedy that is really made available to complainants is financial compensation. But at each step of the grievance mechanism, the Acacia have put forward sort of 2 mechanisms in which either the identification of the adverse impact could be made, or the remedy could be identified. And that is either through a process called dialogue and engagement, where representatives from the mine and the complainant could try to reach an agreement together. Or if the complainant does not wish to participate in that process or that mechanism of arriving at an agreement, an independent review committee could be convened, and the complainant could bring their concerns to that committee to resolve their grievances. And RAID in their report also outlined how there were certain teams at the North Mara mine that were responsible sort of for administering the grievance mechanism. The first is a community grievance team, which was appointed by the mine and mandated to administer and coordinate all aspects of the grievance process. The Community Impacts and Remedies Investigation Team, responsible for investigating claims, and the Community Grievance Committee, which was almost like an appellate sort of body where a complainant, if they wanted to, had recourse to this body if they were unable to reach an agreement with the mine. And that is essentially them participating in the independent review stage of the process. And so despite this really well thought out grievance mechanism that was an effort to actually address the concerns of the local community with respect to the violence that was carried out at the mine, a number of concerns, as you can imagine, were raised by Mining Watch and RAID in separate reports. And these concern largely the extent to which complainants did not have sort of full representation in the grievance mechanism, and really were not treated as equal parties to the complaints that they were raising. Oftentimes they were not in a position to actually access lawyers. They a number of pieces of evidence were not disclosed to the complainants. Oftentimes the complainants were not satisfied with the remedies that were proposed. And they really were, in a number of instances, prohibited from seeking other avenues of redress outside of the mechanism. And so that's really where, seeing and hearing all of this that's been taking place in Tanzania, that really frames for me, as I said, this conception of state transformation that I'm really interested in exploring further. And I'm still developing sort of my ideas in this area. And so this is really like my first attempt at articulating them to an audience of any kind. And I will continue to sort of refine my theories around this to try to develop, as I said, this taxonomy of state transformation arising from mining conflicts involving Canadian companies. And the way that I framed it thus far is to really think about it as institutional subversion and alteration. And from the North Mara example, I really see this taking place in three key ways. The first is that the grievance mechanism has limited access to remedy. And as such, complainants or individuals that have been affected by the conduct at the mine really have no other recourse beyond that grievance mechanism. And so as such, you are in effect sort of obstructing these community members' access to remedy, which has an adverse institutional impact, in my opinion, or the way that I'm going to explore this idea further, on the legal system. And that takes me to the sort of second way in which this grievance mechanism is contributing to institutional subversion and alteration. And that's through the obstruction of the development of human rights jurisprudence through Tanzanian courts or through Tanzanian developed grievance mechanisms, whether they be judicial or non-judicial. In effect, we really do see, as the title of my presentation suggests, corporate control over human rights and the adjudication of human rights grievances in Tanzania because local mechanisms to actually address these grievances have actually not been developed. And the third is through the altered positionality of the Tanzanian government in relation to the mine. The new Twiga joint venture has made the Tanzanian government an active partner in the mine, to the effect that essentially after the 2019 Barrick acquisition of the outstanding Acacia shares and the creation of the Twiga joint venture, that the grievance mechanism that was launched in 2014 and revised in 2017 has completely been abandoned. And the Tanzanian government has essentially become complicit in the ongoing human rights violations that are taking place at the mine. Now, in 2019, when the joint venture was announced, Barrick and the government of Tanzania did express a willingness to create what they called an Africa-focused international dispute resolution framework. Now, what that will actually entail, or what they actually imagine could be addressed by this framework, hasn't actually been announced in any way. And since that time, as I said, even with the ongoing violence that has been taking place at the mine, any recourse for community members that have been affected by it have essentially just become completely non-existent. And so I'll wrap up my comments here because I know we only have until 1:20, and so I do want to leave some time for questions. And I'm really eager to hear some of any comments or questions that you might have as I further think through this project. And as I said, I'm theorizing around state transformation as it relates to mining conflict. So thank you very much for your time.
We have people on Zoom and we have a habit of letting the students have first questions. So the room on Zoom.
I guess my presentation was that thorough? Yes.
Thank you so much for your presentation. My question is about the next. So you said that there were signs of pandemic.
Yeah.
But if you were not so what does that look like?
Yeah. So I think I have to repeat question for Zoom audience, right? So the question was sort of what are my next plans with the project and what exactly would the field work entail? And so I mean, law is a social science. So the type of field work that would take place in law, I mean, it could vary, but what I have in mind is almost, I would say anthropological might sound sort of be bit of a misstatement as to what it would entail, but really what I'm looking to do is to go to the mine site in Tanzania and in Zambia, meet with members of the local communities, meet with company representatives if they're willing, also attempting to meet with government representatives, especially in Tanzania, because I have some context there, and there's indicating that there is some work that's being done on the creation of a grievance mechanism. So I'd be curious to hear more about what the plans are for that and what it could potentially look like. So the type of legal field work that I have planned is not too far off from what typically takes place in social sciences, just other social science disciplines. You're welcome. Okay, yeah.
We have a question from the chat from Ari, who said, do you see any parallels with issues at Northern Mara and coastal gas?
That's a very interesting question. A lot of, I know that my work has a very African focus, but I do oftentimes see parallels between what is taking place in Africa and what we see here in Canada. I think the extent of institutional subversion that we're seeing in Canada is less so of deliberate mechanisms to sort of alter institutions, or not even deliberate, but even unintentional efforts to alter or subvert those institutions, but it's more so using the institutions that are in place to advance corporate objectives. So we know with Coastal GasLink, like the use of injunctions, for example, has really been used and employed by Coastal GasLink to remove the Wet'suwet'en protesters from the site, to try to ensure that the blockades that have been put up can no longer be put up, and to use the police forces as a way to actually enforce these injunctions. So in that case, the companies are using, or Coastal GasLink is already using legal mechanisms that exist to advance their own corporate interests. So rather than seeing it being a subversion, it is a utilization of mechanisms that are already in place. And a lot has been written about. So, I mean, if Arif is interested in sort of learning more about the mechanisms that Coastal GasLink uses to advance their corporate interests, especially through injunctions and the use of police, a lot has actually been written about that by legal scholars in Canada. So there are parallels to some extent, but I think what we are seeing in the African context, given the governance environment in a lot of these countries, is institutional subversion, or even to some extent, sort of institutional creation that really deliberately advances corporate interests. Yeah. Sarah, you had a question too.
Yeah, lots of things I want to ask you about, but I'll
Yeah.
just pick one. In this effort to kind of articulate a taxonomy dealing with state transformation, just wondering, is the idea of enclosure, how to establish enclosure, one of those, or separate, and are there preconditions that so is there something pre-existing in Numara, other things that really kind of amplifies the ability to develop sort of
Yeah, no, that's also a very great question. I mean, I think, Dr. Zabowski, oh, sorry, repeat the question for the Zoom audience. Yes. So Terry's question was sort of, am I, in the theorizing of this taxonomy, the way in which I'm using the legal enclosure, and if I'm theorizing any sort of preconditions that sort of make these particular conflicts or these particular mine sites or legal enclosures that emerge around these mine sites sort of more conducive to this to state transformation. And so Dr. Zabowski and the work that he's done on sort of legal enclosures has sort of really, I think, in my opinion, encapsulated and captured what the way in which legal enclosures could be theorized in mining conflicts. I hadn't turned my attention to thinking about preconditions that are in place and that are often evident or present in a lot of these conflicts. I think that would be an interesting thing to think about. But the way I framed my project is more thinking about the after effects. Yeah, because often times when, or at least in the literature that we currently have on mining conflicts, a lot has been written as some of the, some of the preconditions that you could see or what can precipitate a mining conflict. So questions around land and land ownership is a common one. Do local communities that have been displaced as is another common feature as well of mining conflicts. And so I'm more curious and interested in seeing, okay, once questions of land that haven't been settled or have been sort of resolved in a way that does not account for the ownership rights of local communities, what then is in place? And the same question with displacement. What mechanisms are in place to have allowed that to take place, and if there has been any recourse for local communities at all that have been sort of forcefully evicted from a site that could potentially be mined, and what effect does that have on the institutional arrangement in the country where this is taking place now? Yes. Mhm. Mhm. Yeah, no, that's a helpful question. So the question is whether I've observed sort of a inability or prohibition on accessing or limited access to remedy prior to the creation of the grievance mechanisms in order to sort of verify my thesis. And then if that was the case, or regardless of whether that was the case, if subsequently, if I'm seeing that this grievance mechanism is being used to, I guess, obstruct access to remedy such that it contributes to state transformation. Did I get that, sort of summarize that correctly? Okay. And then in my observations thus far, and again, this is a lot of the research that has been done by NGOs on the ground, because as I said, the reports of violence at the mine started in the late 2000s, early 2010s. And from my reading of what the first-hand accounts from those affected by the violence there, it seems like there was absolutely, I don't want to say absolutely, because that sounds like there were no opportunities, but it seemed like there were limited opportunities to pursue remedy, either even going through, the local police, because oftentimes it was the local police that were actively, carrying out these acts of violence. And then to sort of support or verify that finding, this is not something that I've gone into in much detail in today's presentation, just due to the lack of time, but I have not come across any type of judicial cases in Tanzania prior to the creation of the mechanism or since the creation of the mechanism. And instead, what the affected community members, some of them have attempted to do, is bring a lawsuit outside of Tanzania in the United Kingdom against Acacia as it was incorporated in the UK. And seeking transnational tort remedies is something that has taken place in a lot of mining conflicts. Canada itself has been, we've seen a trio of cases go through Canadian courts around, abuses that have taken place abroad by Canadian companies, and the victims seeking redress here in Canada. But my interest is more in thinking about, okay, regardless of whether or not individuals would seek remedy outside of their home country, what is taking place within that environment. And I think what we are seeing is, I mean, I can't speak to Barrick's motivations or Acacia's motivations, but it does seem to, in some of the firsthand accounts that were raised by victims at the mine, that they were being prohibited from bringing a claim outside of the mechanism within local Tanzanian courts. So it does seem like there was effort at institutional subversion by prohibiting access to local local judicial mechanisms. And so as a result of that, that leads me to theorize it as an issue of state transformation, because we are seeing the inability of the judiciary and the judicial system in Tanzania to develop a jurisprudence around human rights as it relates to these mining projects. Okay, so I've gotten the sign that there's no time left. So thank you very much for joining me today. And to those of you online as well. Yeah,